In our guests tonight, we do have trial attorney C.K. Hoffler, also Seth Berenzweig, who is a litigation and constitutional attorney. Folks, what do you have? Tell us what you're thinking as we're watching the motorcade here getting to Fulton County Jail. Why don't I start with you, Seth?
Well, it's certainly a unique moment in history. It is true that this is the fourth time that the president is turning himself in, so he'll be out on bond in 4 cases. But this is nevertheless unique this evening because you have a case where a former president of the United States has been accused of a RICO enterprise. And this is therefore something that is substantively unlike anything we've seen before. This is therefore on the substance a very unique and novel case, at least in terms of the defendant and the enterprise at issue. And it's also a unique case in this context from a procedural standpoint, because although at the moment you've got 19 defendants, I can assure you that several of them will drop off and plead, and each of those will fall like a brick onto Donald Trump, which exposes unique risks. So certainly we have a unique moment in history, particularly in light of the unique nature of this case.
It is a unique moment. All right, Seth, thank you. And Michael is still with us tonight. Michael, I want to bring you in here, too. You can ask some questions as well.
Yeah, CK, hi, Michael Ayala here. Great to see you, CK. Thanks again for joining us here tonight. The question I want to ask you, earlier today, we saw a situation where one of the defendants in the case has decided to not waive his speedy trial rights, and Fani Willis said, no problem. You know, she's got this under control. I want a trial date in October. She was granted a trial date in October. Hard to believe that they'll be able to get all this together at that time. So what are some of the issues at play? First of all, with a defendant not waiving his right to speedy trial and Fani Willis putting her foot down and saying, we're gonna go to trial in October.
Well, the one thing that we have to realize is that Fani Willis, the district attorney of Fulton County, has had 2 years to investigate, to plan, to research, and to look at every single aspect of this case from the vantage point of all 19 defendants that she decided to charge. That's the first thing. She intended, articulated at the time of the indictment, that she was planning on having a speedy trial. She wanted a trial date in October. So what we are seeing now is a district attorney who is sticking to her guns. There are a lot of procedural issues. As you know, Michael, there are going to be motions on top of motions on top of motions. We've already seen motions to remove the case to federal court. And my prediction on that is that the case will be remanded back to state court. Any defendant can seek to remove a case to federal court, but in this case, because of the way that it has been structured, the way it's been executed, the way it's been planned, the way it's been researched, my prediction is that it will be remanded back to state court in Fulton County, despite the numerous motions that every single defendant is expected to file. And the district attorney has made it very clear that she is going to proceed and will have a trial date in October. So historic, this is beyond historic, Michael, on so many levels, from a constitutional level, from just the issues, from the RICO charges, and there's a reason why it's being tried under RICO. This is a RICO case. It's because Georgia RICO statutes are unlike the statutes in any other state in this nation. And I think that is very important. So I think that people must realize that this district attorney has looked at these issues and done a lot of work for a period of 2 years. And all of these legal challenges that we are about to see, the motions have been completely anticipated because she had the benefit of bringing her case when she was ready.
Yeah, preparation is what it's all about. Seth, quickly, I just have a question for you. You know, the historic nature of this cannot be overstated. What we're talking about here is a prosecutor saying that a former president is the head of a criminal enterprise. That just put that and think about that for a little while. But here's a question, and it was raised a little bit by CK, where this case might end up. The big question is, obviously, President Trump, a couple of the other defendants are going to want to move this to federal court, believing that's a better forum for them. And the question is, for him, were the acts that he's being accused of part of the furtherance of his office, or whether they were just acts that fall outside of the duties of his office? That may have a major bearing on whether this ends up in state court or federal court. Your thoughts on that?
Well, absolutely. And I think you've really nailed the distinction on the head. Mark Meadows has already tried this route, and the president probably will eventually as well as some of the other defendants. The problem is in that distinction, and the allegations in that regard are not that these were matters and conduct that occurred within the scope of their employment as employees of the United States government, but rather they were trying to overturn the election and to try to overturn the results of an election for the United States government. This is absolutely out of the ordinary and reasonable scope of the job. Criming a coup is nothing to do with the job description. So it absolutely will probably see attempts to remove it to federal court. The process is first easy. The defendant files a 2-page notice of removal that goes to the federal court, but then there is a hearing and a motion to remand back. And I agree, it will be remanded back to the state court. This is not going anywhere in the long term. We're going to have a trial in some manner or fashion. It will deliver a verdict before the election. And this case is going to be a huge uphill battle for the former president. And really the centerpiece and an example of this case of the enterprise, of course, is the phone call to Brad Raffensperger, where he said that he wants him to find 11,780 votes. And, you really can't get much more blunt than that. If you look at the counts in the charges, it's very simple: submission of false statements, submission of false documents, felony computer breach, and this is all in furtherance of the enterprise. So this is really a historic case. It will ultimately lead to constitutional issues as well. Really one of the little discussed issues, which will really weigh very heavily, especially next year, is whether the disqualification clause under the 14th Amendment, Section 3, is something that bars the president, the former president, from running again as a matter of law. So keep that in the back of your mind. But you will absolutely see that there will be a lot of jockeying for process. But at the end of the day, there will be no form over substance. We will see a trial in this court on all of these counts.
All right, Seth, thank you so much for your insight tonight.